Okay, well, welcome everyone. We really appreciate you being a part of this really important webinar. Obviously, we are going to be focused this morning on a topic that affects every single one of our campuses. I am truly grateful for the extraordinary network of institutions that we have and the incredible support that I've seen individuals for one another. It has been heartwarming to see the ways in which you've reached out to support one another. And it's been my great pleasure to be a part of some of these efforts. Here at GBHEM, we are doing our best to continue to be your partner in this uncertain time. And to that degree, we have today the opportunity to discuss the CARES Act with two individuals who really are spending a wrestling through this act and directly affects uh, Ian Loos has an incredible piece of that. And Ian, I have forgiven you now for having attended the University of Kentucky. But despite that fact, we are still greatly honored and privileged to have you as a part of this session today. And of course, Bart Darrell, he needs no introduction because I think almost everyone on this webinar is probably going to be familiar with him. Even if you're not familiar with his legal work, which preceded his time in higher education, certainly most of you are certainly going to know him through the service in the university that he did in really helping to expand the student population at that institution and to be a really important work, guidance, institution, really helping us steer through many of effort and support for our network. So we are grateful for all that Bart has done, and we are grateful for Ian's participation and engagement here today, and looking forward to being introduced and to hear from both of them. So before we jump into our presentation on the CARES Act, I have asked Tammy Gieselman, who is one of the members of our office, does great work directly. I've asked her if she would be willing to open our session with a brief blessing. Tammy?
I invite you all to pray with me. Merciful and loving God, we come before you as a people who claim higher education as vocation, and we embrace lives dedicated to active learning and scholarship. And we endeavor to prepare young women and men for lives of personal and professional service and leadership. Continually remind us that the work of higher education is an essential component of a global society. God calls us to listen to the prophetic voices that boom and the still small voices of compassion. And when we are challenged for time or find ourselves too busy to make eye contact with the other, tap on our hearts, open them up, and set them on fire. God, these are our prayers. Amen.
Thank you, Tammy. And again, we really are in conversation with and really thinking about each of the institutions that make up our network. Here at GBHEM, we stand ready to be of support in any way that we can during this extraordinary time. So we look forward to our continued engagement on varied fronts. And with that, I will turn this program over to Ian and Bart. And again, thank you both for helping us to think today about the CARES Act and how it might affect our individual institutions. Ian, Bart, thanks.
Thank you, Mark. This is Bart Darrell here, and it's an absolute privilege for us to be with you today. I do know many of you, and I'm glad I see that my friend Sandra Harper's there. The good thing about doing it on Zoom, she can't throw anything at me. And I see Walter Kimbrough there as well. We've done a lot of things together with higher education in the United Methodist Church. And I will tell you that we will get through all this. And I think that going forward, more than ever, our institutions are going to be a critical players in higher education across the landscape and preparing young people to help lead. So I'm very, it is tough times, but I'm very optimistic about where we're all going to end up. And I salute each and every one of you for what you do. So we're very grateful. What we're going to do today, our firm is heavily involved in this, as you've already figured out. We have worked with nonprofit, for-profit, about everything you can think of on this. And Ian Loos here, who is kind of our resident expert on some of the mechanics that apply to all types of entities, is going to run you through a lot of them. We'll also talk about those things that are very specific to higher education. So y'all are very, very busy. You have things to do. So I'm going to turn over the first part to Ian.
Hello, everyone. This is Ian Loos. And as Bart mentioned, very glad and honored to have the chance to speak with all of you today. But also, as Bart recognized, know that you have lots going on, lots of things to deal with. So we will try and move through this as efficiently as we can. And just in terms of an outline of the agenda for today, we're gonna hit on three main topics. The first is the Paycheck Protection Program, which is part of the CARES Act, which has been referred to as the Senate stimulus bill. The Paycheck Protection Program is a loan program. We'll spend some time talking about that. We will then discuss the Families First Coronavirus Response Act. That's the first federal legislation that was passed almost a month ago now that deals with employment matters. And then Bart is going to take the reins on the CARES Act and the higher education provisions, including the Education Stabilization Fund, and how that may work in a can everyone hear me okay?
You're kind of breaking up every so often.
Okay. I'm not sure if that's the connection or not. How is that a little better?
Yeah, if you say a sentence and see if you can get all the way through it, because you're kind of breaking up every three or four, third or fourth word. Okay.
How are we doing now? Is this a little better?
Yeah, that's better.
Okay, wonderful. As I mentioned, there's two main federal laws that deal with the coronavirus, the Families First Coronavirus Response Act and the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. The first one we're going to talk about is part of the CARES Act, which is the Paycheck Protection Program. This is a lending program that is an expansion of an existing Small Business Administration loan program. Approximately $349 billion has been appropriated to this program. It is on a first-come, first-served basis, but the Treasury Secretary has, within the past week or so, requested an additional $250 billion in funding for this program. I'm not sure if that will pass or not. But hopefully additional funding can be made for this program. If an entity receives a loan under this program, they will be able to use those funds for their payroll costs, pay expenses such as mortgages and rents, utilities, and interest on other debts and obligations they have through their business.
You're speaking, I can't hear you at all now.
Can you hear me? Can you hear me now?
Yes.
Okay. I'll try and speak as directly into the microphone or the computer here as I can. In terms of eligibility for the Paycheck Protection Program, only entities described and defined as a small business concern is eligible for a loan under this program. And the definition of small business concern has been, is pretty broad. It applies to businesses with 500 or fewer employees. And this won't apply to you all because there's not a separate specific employee number listed for institutions of higher education. But for other businesses, there may be separate industry standard employee numbers. And importantly for you all, the definition of employee includes all full-time and part-time employees, and that would include work-study employees as well. That would include everyone who is working part-time, whether it's under work-study or whether it's a traditional employee, part-time employee of the university. In terms of the amount that you can obtain in one of these loans, the maximum amount for any business entity is $10 million, but it will be capped at 2.5 times your average monthly payroll costs. And they look at that average from the 12 months preceding the date of the loan. Seasonal employers can use slightly different periods, but I don't think that's going to apply to you all on this one. But seasonal employers can use different 12-week periods to obtain what their average payroll costs are. We will talk here in a minute what the definition of payroll costs is under this act, because that is very important. But entities that have received an economic impact disaster loan after January 31st of this year are able to refinance those economic injury disaster loans into a PPP loan as well. And in terms of counting employees, independent contractors are not included. There are some situations where if you use a staffing company or if you have joint employees, those employees may be included, but that very much is a case-by-case determination. So determining what your payroll costs are and the definition of payroll costs, it includes all of your employee wages, salary, compensation. But as you see down at the bottom underneath the excluded portion, that does not include any amounts paid above $100,000 for one employee. So if an employee is earning more than $100,000 on an annual basis, the first $100,000 that employee is being paid will count as payroll costs, but any amount beyond that first $100,000 will not count. Any amount that is paid to an employee for paid vacation, parental leave, family leave, sick leave, that all counts as payroll costs. There is an allowance for dismissal or severance. I've not seen any regulations on that at this point, but I imagine there will be some reasonableness regulations as it relates to what amount or what kind of severance may be included. Retirement benefits, any amounts that are paid as a retirement benefit, contributions to 401ks, those sorts of things, those expenses are included in the definition of payroll cost, as are group health benefits, any amounts that you pay for health insurance premiums for employees, those are all included. The big exclusions down at the bottom there are compensation to an employee who resides outside of the United States, as well as paid leave under the Families First Coronavirus Response Act. We'll talk about that in a little bit, but amounts paid under that act are not included, as well as payroll taxes and federal withholdings. Those are not included in the definition of payroll costs. So again, to determine how much of a loan under the PPP program you can take, you must first determine your average monthly payroll costs based on this definition of payroll provided here, and multiply that by 2.5 times. And again, as I mentioned earlier, you can also refinance an economic injury disaster loan into a PPP loan, so long as that economic injury disaster loan was taken after January 31st of 2020. So that can be refinanced into the PPP loan. The big benefit and the big draw on these PPP loans is the potential forgiveness. And that's really what has caused a lot of businesses to apply for these loans as soon as possible. Anytime you can obtain a loan to assist your employees and have that loan forgiven, just about every business in the country is going to be interested in that. So borrowers shall be entitled to forgiveness. And the important part about this is it is for costs incurred and amounts paid in the 8 weeks following the date of the loan. So the federal government is wanting to ensure that these funds are used and they're used quickly. And the way that they're doing that is you can only obtain forgiveness for amounts spent in the 8 weeks following the date of your loan. And you can obtain forgiveness for amounts spent on payroll costs. Again, that excludes any pay to employees beyond $100,000 as annualized. So if you annualize the pay of an employee in that 8-week period, it can't be greater than $100,000 if it were spread across an entire year. You are allowed to, as I mentioned at the outset, you're allowed to use the funds to make mortgage payments, but only the interest on those mortgage payments is forgivable. Now, rent payments are forgivable in their entirety. And of course, those lease agreements, those mortgage agreements, those debts must have been taken out prior to February 15, 2020. I think that's a protection just to ensure no self-dealing, someone not trying to take advantage of this program by entering into a high lease, on March 1st, and then using this program to fund that lease and obtain forgiveness. Utility payments are included as well. That service must have been established before February 15th, 2020. And this last one is big. This is not included in the text of the CARES Act itself. This is something that the Department of the Treasury has included somewhat on its own in the regulations. And that is the bottom bullet point there. No more than 25% of the forgiveness amount may be attributed to non-payroll costs. So you can't have more than 25% of your forgiveness amount be related to rent payments or utility payments. 75% must be payroll costs. Again, that's defined, going back one slide, that's defined to include employee wages, amounts paid for vacation or sick leave, retirement benefits, group health benefits. It is a broad category, but 75% of the forgiveness amount must be payroll costs as defined by the Act. And of course, it wouldn't be a federal act if it didn't include some limitations on the forgiveness. And there's two main limitations on forgiveness. The first is if you reduce the number of employees you have, and the second is if you reduce the pay of those employees in the 8 weeks following the date of the loan. So the way to determine, and it's a fairly complex calculation, the way to determine if your forgiveness amount will be reduced due to a reduction of employees is, first you must determine the number of full-time equivalent employees in the 8 weeks following the date of the loan. Unfortunately, at this point, the Department of the Treasury has not yet defined for us what full-time equivalent employee means. There are various different definitions throughout the federal government. Some are based on 30 hours, some are based on 32. Many people just assume full-time is 40 hours. So we're waiting on guidance from the Treasury Department in terms of what definition they will use for full-time equivalent employees. But you must determine the number of full-time equivalent employees per month in the 8 weeks following the date of the loan, and compare that to the average number of full-time equivalent employees for the period from February 15, 2019 to June 30th, 2019, or, and this is in the employer's discretion, from January 1st, 2020 to February 29, 2020. And I think that's intended to allow, there may have been some non-coronavirus related changes in staffing, which those two different windows allow a business to determine which is more favorable to us. So you determine the proportion of employees, average full-time employees per month in the 8 weeks following the date of the loan, and compare that to one of those two time periods. And if you have a decrease, your loan forgiveness amount will be reduced proportionally. Now, the second way loan forgiveness may be reduced, that is if your employees' wages are reduced by greater than 25% in the 8 weeks following the date of the loan. That does not apply to employees who make greater than $100,000 per year. And one thing that we do expect some clarification on is that reduction right now is 8 weeks following the date of the loan, and that is compared to the last full quarter. So we're comparing 8 weeks to 12 weeks. We're comparing 8 weeks of pay versus 12 weeks. I expect that will be cleared up in a regulation. We expect a regulation within a week or two dealing more with the forgiveness part. But that 25% is not an across-the-board 25%. That is a 25% per employee. If one single employee has their pay or salary reduced by more than 25% in that 8 week period following the date of the loan, your forgiveness will be reduced accordingly. And it's my understanding that that is a dollar for dollar reduction, whereas with a reduction in the number of employees, that is a proportional reduction. And just some broad brush terms which are important and will apply to the extent the loans are not forgiven. There is an automatic 6-month deferment from the date of the loan. No questions asked. You're entitled to it as soon as the loan is issued and funded. The standard term will be a term of 2 years. The interest rate will be 1%. And importantly, being in higher education, I'm sure this is something that you all have considered in relation to the public service loan forgiveness of some of your students. Any amounts forgiven for these PPP loans will not be treated as discharge of indebtedness income. I know that's a topic that has been touched on again with the student loan forgiveness, where the forgiveness is a great thing, but then there's a large tax bill on the back end. The government was express in this bill saying that will not count as discharge of indebtedness income for the borrower. And there will be no personal guarantee or security. They can't ask for a mortgage, and there's no recourse. against any owner, except for to the extent that they use the funds for impermissible purposes. If you use these funds, if they're embezzled or you use them for a purpose other than those which are permitted by the act, there may be personal liability, including criminal liability, for that. Moving on to the Families First Coronavirus Response Act. This, I imagine you all have a bit more familiarity with because it's been out for almost a month now, and it went into effect on April 1st of this month. But it does contain two main programs that provides leave for employees. The first being the Paid Emergency Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. Both of those acts are set to expire on December 31st, 2020, unless, again, Congress may choose to expand some of these depending on how long we remain in these trying times. But as of right now, both of those programs are scheduled to expire on December 31st. And there is also a payroll tax credit for employers for any amounts paid under these programs. So I do my best to stay away from tax, but I would encourage anyone to discuss with their accountants, their payroll people, how that might be impacted, how that may benefit them if they are making payments. Now, first, with regard to the Paid Emergency Sick Leave Act, this applies to employers with fewer than 500 employees. Again, that definition of employee includes all full and part-time employees, regardless of how many or how few hours a part-time employee works. There are some exceptions where employers may exclude from coverage under this act and the expanded FMLA as well. Employers in their discretion can exclude from coverage healthcare providers and emergency responders. And the definition of healthcare provider and emergency responder are fairly broad. I don't imagine that will apply to you all, particularly with most campuses shut down. But regulations have provided some fairly expansive definitions of healthcare providers and emergency responders. Under this act, employees who are unable to work or telework, if you're unable to physically come and work in person, or if you are unable to work remotely, as I imagine everyone on here is doing through the use of Zoom and remote access through computers, employees are entitled to up to 80 hours of paid emergency sick leave. And they're not entitled to that just to take whenever they want. They're only entitled to it if they meet one of these bulleted conditions. The first is if they're quarantined after they have been diagnosed with coronavirus, or if they have been recommended by a medical professional to quarantine. They're also entitled if they themselves are seeking a diagnosis for coronavirus because they've been exhibiting symptoms but are awaiting that diagnosis or medical treatment. And the last one, which is, I think will catch far more people than the first two, and that is if you're providing care to a family member who has been quarantined or diagnosed with coronavirus, or if you have to provide child care to your children because their schools are closed or their daycares are closed. Though that one is what we're seeing far more of. Parents having to stay home to tend to their children, to help with the electronic school, the online school that the children are having to do. And it's important under this act, employees are immediately eligible. They don't have to have been employed by the employer for 30 days. Employees under the Paid Emergency Sick Leave Act are immediately eligible for these benefits. There's up to 80 hours. Up to 80 hours. And then to determine how many hours, again, capped at that 80, to determine how many hours an employee is entitled to. They are entitled to twice what their average weekly number of hours would be. So however many hours they would work on average over a 2-week period, capped at 80 hours. Some employees do have variable schedules. I would imagine that would apply to some, mostly part-time, if they're working a few hours here and a few hours there. You can look back at the 6-month average, the average number of hours they've worked per week over the preceding 6 months, and use that to determine how many hours they're entitled to leave under this program. And of course, the total number of hours is capped at 80. But employees who typically work 50 hours a week, they're entitled to take 50 hours leave in the first week. That leaves them with 30 hours remaining, and then take in a second week 30 hours. But again, there's some caps on the pay rate, which we'll talk about right now. Employees who are taking leave because they are quarantined or they have their own coronavirus symptoms, they're entitled to their full rate of pay, not to exceed 511 hours per day, $511 per day, excuse me, and $5,110 in aggregate over their full 2-week period. But employees taking leave to care for a family member who's quarantined or to care for a child who's no longer in school or daycare, they are only entitled to 2/3 of their regular rate of pay, not to exceed $200 per day, $2,000 in aggregate. So as I mentioned before, an employee who typically works 50 hours a week can take 50 hours of this paid leave in 1 week, but they are subject to this $200 a day cap or the $511 per day cap. And if they are taking more than 40 hours in 1 week, they are not entitled to an overtime premium, which they would be entitled to for working beyond 40 hours in 1 week. Because again, they're not working. This is just a leave benefit for them. The other part of the Families First Coronavirus Response Act is the Paid Emergency Sick Leave Act. This applies to employers with fewer than 500 employees, and it's an expansion of traditional FMLA. Traditional FMLA applies to many fewer employers than this expanded. Typically, it doesn't apply to employers with fewer than 50 employees, but this applies to all employers with fewer than 500 employees. Again, there are exceptions for healthcare providers and emergency responders, as well as there are some circumstances where employers with fewer than 50 employees may be excluded. That is a very case-by-case analysis, so we won't get too much into that. But if you do have questions and think you might be eligible for that, please reach out to us afterwards. There we go. For an employee to be eligible for this expanded FMLA leave, they must have worked for the employer for 30 calendar days. They must have been on the payroll for 30 days. That doesn't mean they have to have worked physically on location for 30 days. They must be in the payroll system for 30 days from their start date. And again, very much like the emergency paid sick leave, this only applies to employees who cannot work or telework. If someone is able to work remotely, they're not entitled to this benefit. And further limiting the circumstances, this expanded FMLA only applies if an employee is unable to work or telework due to the closure of school or daycare. That's the only circumstance under which this expanded FMLA provision applies. if an employee has been diagnosed with coronavirus or they need to care for a family member who has been diagnosed with coronavirus, they are not eligible for this expanded paid FMLA leave, but they may be entitled to traditional unpaid FMLA leave depending on the circumstances. So that's kind of the relationship between these two FMLA provisions. Under this expanded FMLA, employees are eligible for up to 12 weeks of paid public health emergency FMLA leave. And again, that only applies if they must care for their child due to school closure or closure of daycares. And they're only entitled to 12 weeks total. So if they have taken between this FMLA and traditional FMLA. So if an employee in the preceding 12 months has taken traditional unpaid FMLA leave, their entitlement to this paid expanded FMLA leave will be reduced. So be certain to look back and see if someone has taken unpaid traditional leave to recover or for treatment of a serious medical condition. Under this expanded FMLA, the first 10 days is unpaid. The first 2 working weeks is unpaid, but employees may use the 80 hours or the up to 80 hours worth of the paid emergency sick leave, or they may choose to use accrued vacation or sick time. After those first 10 weeks, after the first 10 days, the following 10 weeks, the employee is entitled to be paid at 2/3 their regular rate of pay, not to exceed $200 per day, and not to exceed $10,000 in aggregate. Now, the Department of Labor has come out and indicated the employee may choose and the employer may require that vacation or accrued time may be used during that 10 weeks of paid FMLA leave. However, if that is the case, the employee must be paid their full rate of pay. They aren't subject to the $200 per day cap if you are requiring they use their sick leave. And again, that's similar to, that's identical to traditional FMLA. Those are, that's the employment side of things and the Paycheck Protection Program side of things. I'll turn it over to Bart, who's going to touch more on the higher education.
Well, what you're navigating right now, I guess, is a lot like trying to keep frogs in a wheelbarrow. If you can picture that, because everybody's moving in different directions. We're trying to keep everybody headed to the same end result in all that we do. First of all, I want to go ahead and give you, if you want to put this down, I'm going to give you my cell number as well as my email address in case anybody needs me. And Ian will do the same before we leave. But my email address is Darrell, that's DARRELL, at B as in boy, OAM as in Mary, law.com. It's Darrell at boamlaw.com. My telephone number is 270-779-4149. Now, as far as the higher ed funding piece of this, there's a lot of unknowns in this, as each and every one of you knows. It's fairly straightforward on the language itself, but the implementation and exactly what's covered is not quite as clear. I can tell you that we are anticipating within the next 2 weeks a little more guidance from the Secretary of Education's office. I assume that many, if not all of you, saw the April 9th, 2020 letter from Betsy DeVos, and it gave some guidance, but it didn't really cover a lot of things that I think we're gonna have to know and have to be concerned with as we go forward. First of all, that as far as the higher ed goes, we know that 90% of the 12 of the money, which equates to about 12.6 billion, goes to higher ed. 75% of that is based upon the full-time equivalent of Pell students, as you know, and you can read easily. And 25% is the full-time equivalent enrollment of non-Pell students. Now, again, what's accepted there are those full-time online students. They are accepted out of that. Now, I want to focus for a few minutes on what you can do with the money. And the language is very clear. They're talking about money directly in the hands of students based on an emergency. The letter from Secretary DeVos says the CARES Act provides institutions with significant discretion on how to award this emergency assistance to students. And of course, what that means is that each institution could come up with a formula or a strategy that they think is best helping their most needy students. The only statutory requirement is that the funds be used to cover expenses that are directly related to disruption of campus operations. And then they go on to define that a little bit. These expenses include students' cost of attendance, which includes food, materials for coursework, of course, housing, that kind of thing. I was involved in a discussion just yesterday, and the big elephant in the room is, of course, the issue of refunds. And at this point, if you read this language, it doesn't appear that that is in there for us. In other words, if students are demanding refunds on room and board, it doesn't suggest that that 50% directly to students can be used. Now, there's been other discussions about is there credit opportunities, those kinds of things. And I know some accounting firms may have given that advice. I don't know that that's correct, but I do think that we're going to get more guidance going forward on this, because that is obviously a huge expense for all of us. And it's not going to go away on its own. Some of the other, there's nothing wrong with just saying, here's the number of students that we have in these categories and distributing the money equally around the student populations. You may have a different format. I think the key thing here is when you decide how to allocate money, how to distribute money to help students, it's going to have something that, state the obvious, that has rational basis, is reasonable, is commonsensical. In other words, if you have a student who doesn't have the ability to go home and has to rent an apartment because they're not in the residence halls anymore, that would seem to be an expense that they're talking about. Student can't eat. They would have been eating in the residence hall. They don't have the ability with other resources. But, that some of that would take an awful lot of investigation and digging on behalf of institutions. So, I think we will get more guidance on this going forward, but the theory obviously is from the federal government, we want the money on this 50% to students to go directly into the hands of students to provide them relief from expenses caused directly by the interruption of services in their academic year. Now, other things that are in this, the requirements that colleges and universities and match the federal funds, and the waiver on limits, the 25% of transferring funds between opportunity grants and federal work study have been relaxed and waived. And so basically what you're talking about is these have all kind of turned into grants, because they're also saying that if a student who has been assigned and awarded work study, federal work study, but obviously is unable to complete that work study because the school is basically shut down, that they are still entitled to be paid. So in effect, that is turned into a grant. Also very important is the Section 3508. It suspends a college university's requirement to return Title IV funds if a student withdraws during a payment period due to this coronavirus and the shutdown that it caused. Now the key is the withdrawal. It doesn't mean students who are still actively participating in online education. They're talking about withdrawal. So there are a lot of mysteries out here on this and exactly how these funds are going to be used. And again, as I was told yesterday, that we can expect a little more guidance very, very soon. But the elephant in the room is going to be the refund. And one thing I would say about that, depending on which side of this 50% money some of you may be thinking about in terms of using or applying somehow in a creative way to offset these amounts of refund. If someone were down the line to determine that a refund could be considered a good use of some of the money that we're getting or may end up getting, I think I would be careful to do it before then, because it could be seen as something you've already done. And it's not something that the institution still has a need for because they've done it. And I just caution you on that. That's not legal advice, because we don't know ultimately what the rules are going to be. But I would just say keep that in mind if some of you are thinking about proceeding with refund, if you have any plan at all or hope that federal funds might be used to offset that. At this point, I'd like to open some of this up to questions on any of these topics. I know we've been going for about 50 minutes, and we'd like to make sure that we know what we think about every day, but we want to know what's on your mind, what we can do to help you.
This is Fred Slayback at Texas Wesleyan University, and there's been a lot of conversation recently about whether or not the CARES Act student funds can be applied to students' accounts to pay balances due. What's your read on that?
Yeah, the latest I've heard is that there is, and I've got this written down here on a note, student account versus emergency expenses. What they're looking at on the federal level is exactly, appears to be what I delineated. And they are not, so far, they're not talking about being able to help student accounts with those funds.
Well, I know that's what the department has said in a press release, but it's certainly not prohibited by on the face of the statute itself, and they've not promulgated any regulations. So I'm wondering where they're coming up with that.
I do not disagree with you. The only guidance we really have on that is things like the letter from the secretary, and that's why I said there's a lot of confusion, a lot of mystery on this, and hopefully, in the next 10 days to 2 weeks, we'll have answers to those and other questions. I agree with you. It doesn't say that.
Bart, this is Sandra on the same question.
Sandra.
It seems like, are we going to have, it's the student account question, but we've already gotten like students that are on a payment plan.
Right.
And then they've said, or their parents have said, well, we can't make the payment plan because our situation has changed dramatically, since we've made the payment plan and we've been laid off or whatever the situation is. And so are we going to have to document that? Because to me, that is a fairly direct emergency response, but it would only, it seems like they're trying to slice it so thinly that only those kinds of things would be able to help out with student accounts.
Yeah, and I hate to be vague, but that's a huge question. Now, one argument, one of the considerations on that, Sandra, is this talks about expenses that were not already incurred prior to this. Somebody might try to argue, well, you allow a payment plan, but it was really due, when you started. You allow people to pay it over time, which everybody obviously does. The second piece is, of course, we're probably going to get into a lot of arguments about what is directly related to the virus.
Right.
And somebody's financial condition prior to may or may not be a factor. I'd like to say I've got the crystal ball, can, give you all those answers, but right now we don't know yet. But those are the questions that have to be continually raised, and I would encourage everybody on things like that to beat your legislators up as much as you can, because as I learned, being in the private practice of law for 25 years and being a college president, maybe you wouldn't be surprised how very little everybody else knows about what we do in higher ed, particularly at our level. Don't assume these people understand this.
Right. I guess I'm wondering whether there's going to be, if you have to directly relate it, are we going to be in a situation where it's difficult to award the money that we've gotten because it's going to be difficult to document directly relating it to the virus?
I agree with you, and I think that is one of the reasons that if you look at the secretary's letter, if you haven't seen it, it's a little over a page and says a lot, but leaves a lot of unanswered questions. But she seemed to encourage use of Pell Grant threshold as one of the measures of how you do that. And, when the federal government, this is a political statement, when the federal government says they're going to provide you with significant discretion on the use of their money, I have no idea what you need to do with it.
Have we lost him?
Bart,
We're here. Right here.
okay, you broke up. I think we lost your sound there for a moment.
Okay. I was just saying, anytime they tell you have all the discretion you want, pretty much, that means they don't understand the mission or what you're dealing with. And how many of you have ever gotten a Title III grant and they said, do whatever you want with it? It doesn't happen.
Bart, just as a follow-up to what Sandra had been asking, I was on a call with some of the folks at NICU yesterday, and one of the questions with be required expenses.
Mark, you cut out on me. I couldn't hear you.
Okay. Bart, so I was on a call with NICU yesterday, and one of the questions that arose had to do with what might documentation relative to monies through this act being provided.
I'm sorry, you're cutting out real bad. I think your question was, what does documentation look like?
Bart?
Yeah,
Bart?
well, I'm here.
Your voice here.
I can hear. I can't hear you at all. You're cutting out every other word.
Okay.
Were you asking about what does documentation look like?
I can hear Mark Hanshaw.
Okay, I can't for some reason.
Let me, Bart, I'm just gonna send the question by chat.
Sure, that'd be great. That'd be great. Another issue is the taxability to the student when these monies are distributed. And it seems to be, if they may be, then there's that question about whether institutions are having to issue 1099s and things like that. And again, I hope we get more guidance on that soon. Other questions?
Yeah, this is Chris Plunkett at Iowa Wesleyan. On the taxability issue, Gary Stanke of IQ distributed a really interesting example this morning of the way that one might proceed with distributing this. And one of the pieces of that was that he said the taxability question seems to have not been answered clearly yet. At the moment, It sounds like it is supposed to be taxable, but that seems odd because federal financial aid is not taxable. His recommended approach, and I'm curious what you think, to every student COVID-19 received, you may or may not need this, but you will need to work that out with your accountant at the end of the year. And that way it separates the institution from turning into a tax accountant. It kind of right up front, it says, we may not need this, but we're going to give it to you anyway. And then it's in your lap to figure it out with your accountant.
I totally agree. It's not one of the things you want to have to clean up later, I guess.
Bart, I texted you my question, and so if you can see that there on chat.
Okay. Okay, that's what I thought you were asking.
Yeah.
Again, there's no guidance on that either, but I would recommend that you keep obviously separate, entirely separate set of documents that detail not just what you paid and to whom, but the formula or the reasoning behind the system itself. That will be the key thing. They're not going to be able to inspect all this stuff, but what they're going to look for is, was it reasonable? Was it consistent with the goal? So in terms of trying to dot every I and cross every T, nobody's going to be able to do that without any, additional guidance. But I think the real key is that there appears to be a well thought out strategy to distribute the funds.
Thanks.
One of the questions that I saw, this is Ian again, one of the questions that I saw in the chat a little bit ago was whether anyone has received funds under a PPP loan. We have helped and advised clients and businesses through whether they should apply in the application process. I'm aware of a number of clients, businesses, and other entities that have applied, have been approved, and have been given the dollar amount that they have been approved for. I don't know whether they have received those funds in their account yet. I don't have anyone calling me saying, pounding their fist on the table saying, where's my money? But I've also not gotten the call saying, hey, the money's hit my account. So I know they are being processed. The first application date, the date the PPP loan application opened was April 3. So we're just at about a little more than 10 days from that. And of course, there's all kinds of approval in the application process. So I don't know if the funds have hit accounts yet, but there have been approvals thus far.
The money did hit university yesterday.
Okay, well, good.
We did apply for it April 3rd.
Okay.
So hopefully those that, and I know some banks weren't prepared to take applications on April 3rd, that Friday. Some, pushed it into the new week. So hopefully more that have been approved will obtain their funds this week, and hopefully it doesn't have to push into next week. And of course, this is almost not even worth indicating, but I have been advising, it's kind of a common sense deal that I imagine all of you will have thought of, but I have been advising clients, put those funds create a whole new account, put those funds into that account. It doesn't need to be at a separate institution. It doesn't need to be, a separate bank, but a separate account. That way, when it comes time to apply for forgiveness, and if there's ever an audit, you can say, okay, this account is only PPP funds. Everything going out of this account is only PPP funds. You don't have to worry about commingling. You don't have to worry about trying to rewind payments where you're telling an auditor, no, this payment for a purpose not permitted under the act was from our operating funds before PPP, whereas those payments were, I think it will be far less of a headache on the back end to create that new account, only put PPP funds in there and make your payments from there. That way you'll have a ledger. All of the payments coming out will be your ledger of what you spent those funds on. So I know Bart gave his, we've got on our screen our office number, both of our emails. Bart gave his cell phone number earlier. I'll give you mine as well. I can be reached there by call or text message or whatever's convenient for you. And that is 270-535-0426. And I think if we did things the right way, this presentation will have been recorded and it will be posted along with the PowerPoints. And if you have any other questions, would like any additional information, please reach out to us.
This is Bart again. One other thing I just want to mention has nothing to do with this legislation, but all of you are going to deal with at one level or another, is the other things that you are required to do, all the timing of all the things that we're required to do as institutions that are set either by federal or state law or our bylaws. You know, those are all going to be issues going forward. For example, I'm involved with a couple of institutions on Title IX investigations right now, and you know, things have come to a standstill, and you have those the terminology like promptly and reasonably in time, and all those things are going to be up in the air. So one of my cautionary words for you would be to, again, maybe even heighten your documentation on things that things can't be done. You know, document that, explain why. I don't think anybody's going to get beaten up over this kind of thing going forward, because everybody understands the situation that we're in. I think it would be a good strategy to even heighten your documentation on things that you have time limitations and requirements on.
Good point.
Anything else?
Bart and Ian, as we close, I simply want to express our extreme gratitude again for your time and your attention toward this topic. This is one that is important to all of us. We are grateful for your partnership and grateful for your support. And so I really want to express again how appreciative we are of having this relationship and how important this network of institutions is, not just to us, but to you as well. And so thank you.
Well, I appreciate that. And, you know, I'm one of you. So this is near and dear to my heart. And as we get more guidance, we are more than happy to revisit this. And we're living this pretty in depth every day, and we'll continue to. It's really important to us. Thank you all.
Yes.
Thank you.
Yeah, thanks everyone. Wish you well, and I hope all is well on each of your campuses. Thank you for being a part of this.
Thank you.